Imagine being Keir Starmer, the former human rights lawyer who built his entire early career defending civil liberties and constitutional principles, and then having the person who literally mentored you in those early days publicly condemn your government's plans to slash jury trials as most unfortunate and fundamentally wrong. That's the spectacular irony unfolding right now as Edward Fitzgerald KC, one of Britain's most acclaimed silks who was made a CBE for his human rights work and literally wrote a book with Starmer, has broken ranks to oppose Labour's plan to cut jury trials in half. We're talking about proposals that would see only the most serious crimes like murder, robbery, and rape tried by jury, while everything else gets processed through swift courts created within Crown courts but operating without juries. So you could be facing years in prison, have your life destroyed by a criminal conviction, lose your job, your reputation, your freedom, but you wouldn't get the right to be judged by 12 of your peers. Instead, a single judge or magistrate makes the call. Speaking of magistrates, they're being handed significantly more power under these proposals. Currently, magistrates can only impose prison sentences of up to 1 year. Under the new system, that limit increases to 18 months. That's a 50% increase in their sentencing power, dealing with offenses where guidelines go beyond the existing 1-year limit. Now, magistrates do important work, and many are dedicated public servants, but they're not professional judges. They're volunteers, often with minimal legal training, making decisions about people's liberty. Increasing their power to impose sentences of 1.5 years is a massive expansion of what's essentially amateur justice. The proposals also strip automatic rights of appeal from defendants, requiring them to seek permission to appeal first. That's a significant procedural change that makes it harder to challenge convictions or sentences you believe are unjust. And complex financial and fraud cases would lose juries to stop jurors from having to give up months of their lives serving on long trials. The government frames this as consideration for jurors, which sounds thoughtful until you realize it's removing democratic oversight from exactly the kind of complex cases where judicial bias or error might be most likely, where powerful defendants with expensive lawyers might most benefit from a single decision-maker rather than 12 ordinary citizens. Edward Fitzgerald's opposition to these plans is particularly significant given his relationship with Starmer. This isn't some random lawyer criticizing the government. This is the man who mentored the Prime Minister in the early days of his legal career. Fitzgerald was one of the founding heads of Doughty Street Chambers when it was established in 1990, and Starmer was among the barristers who joined. These weren't just professional colleagues, they were personal friends. Fitzgerald was among a select few personal friends allowed to welcome Starmer into Downing Street when he became Prime Minister in 2024. They wrote a book together in 2008 about how and when to apply the death penalty in countries where it remains an option. That's not a superficial connection. That's a deep professional and personal relationship spanning decades. So when Fitzgerald tells The Telegraph that it is most unfortunate the government has taken this position, juries should be kept, that's a carefully worded but devastating rebuke. He's not ranting or raving, he's expressing disappointment in language that's restrained but unambiguous. He still supports Starmer personally, adding, "I am a great supporter of Mr. Starmer," but he's making clear that on this fundamental issue of democratic principle, his former mentee is wrong. That must sting on a personal level, having someone who taught you, who guided your early career, who presumably instilled some of the values you claimed to hold, publicly saying you've lost your way. Doughty Street Chambers, where both men worked, has gone even further in its criticism, calling the plans wrong in principle and alleging there's no evidence they'll clear the backlog. That's not just saying we disagree with this policy, that's saying it's fundamentally unjust and won't even achieve its stated purpose. The Chambers issued a statement saying, "Trial by jury is a deeply entrenched constitutional principle and anchors our liberal democracy. Jury trials enable people to participate and have a say in their criminal justice system." That's a direct challenge to the government's entire rationale, arguing that even if clearing backlogs was guaranteed, which it isn't, sacrificing this democratic principle wouldn't be worth it. The opposition from the four bars is even more remarkable because these organizations rarely agree on anything. Getting the senior lawyer associations from England, Wales, Scotland, Northern Ireland, and Ireland to issue a joint statement opposing something is like getting all the cats in a neighborhood to walk in formation. It just doesn't happen unless the issue is genuinely serious. Their joint statement pulled no punches. There is no evidence that this fundamental change will bring down the existing Crown Court backlog. The curtailment of jury trials has predictable negative consequences, including undermining the public's trust and confidence in our criminal justice systems. They continued, trial by a jury is long established and respected throughout the common law world for its veneration of democratic ideals, its age, gender, and ethnic inclusiveness, and its respect for citizens' and judges' roles in the administration of justice. That's about as strong as institutional criticism gets. They're not just defending professional interests, they're defending constitutional principles that define how justice works in democratic societies. And their point about there being no evidence this will clear backlogs is crucial, because it attacks the government's entire justification. If you're sacrificing democratic principles and it won't even solve the problem you claim it'll solve, what's the point? The threat of a backbench rebellion adds another layer of political danger for Starmer. 39 Labour MPs signed an open letter last month indicating they intended to vote down the proposals despite the risk of losing the whip. Losing the whip means being expelled from the parliamentary party, losing committee positions, potentially being deselected for the next election. It's career suicide for most MPs. The fact that 39 of them are willing to risk it suggests the strength of feeling on this issue. These aren't random backbenchers. Many are former lawyers themselves who understand the importance of jury trials and are appalled at what their own government is proposing. The government's defense centers on the Crown Court backlog, which is set to hit 100,000 by 2028. That's genuinely serious. People waiting years for trials, victims denied timely justice, defendants stuck in limbo. Justice delayed is justice denied, as the saying goes. Justice Minister Jake Richards attempted to defend the reforms yesterday, calling them a modest change that would see criminals brought to justice sooner and bring relief to victims. He told Times Radio, "I'll tell you what's the most dangerous part of undermining trust in our justice system. It's the fact that rape victims are having to wait 5-6 years for their day in court, which means too often those trials never happen. Justice is not done, and perpetrators of the most heinous crimes never face justice." That's actually a quite effective argument emotionally. Nobody wants rape victims waiting years for justice. Nobody wants serious criminals walking free because the system can't process cases quickly enough. But here's the problem with that argument. Removing jury trials for everything except the most serious offenses doesn't solve that problem. Rape trials will still have juries under the proposals. Murder will still have juries. The backlog in those serious cases won't be affected. What will happen is that less serious crimes get rushed through swift courts without proper democratic oversight, while the serious cases that Richards claims to care about continue to face delays. It's solving the wrong problem while creating new injustices. The historical context of jury trials makes their importance clear. They're not some modern innovation or administrative convenience. They're a fundamental feature of English common law dating back centuries, literally to Magna Carta and beyond. The right to be judged by a jury of your peers is one of the foundational principles distinguishing democratic societies from authoritarian ones. In dictatorships, judges appointed by and loyal to the state decide your fate. In democracies, ordinary citizens do. That distinction matters enormously. Juries provide a check on state power, ensuring that prosecutions have to convince not just a judge, but 12 ordinary citizens that someone is guilty beyond reasonable doubt. The irony of Starmer, former human rights lawyer, being the one to undermine this principle is almost too perfect. This is a man who spent years arguing cases based on civil liberties, who built his reputation defending constitutional rights, who prosecuted human rights abuses. And now he's in power, and suddenly those principles that seemed so important when he was a lawyer become inconvenient obstacles to administrative efficiency. It's the classic story of how people change when they get power, how principles get abandoned when they conflict with political expediency. But it's particularly jarring when the person doing it spent decades positioning themselves as a defender of exactly those principles. Critics warning that these changes will overwhelm judges have a point that the government hasn't adequately addressed. Judges are already overworked. Court time is limited. If you're routing more cases through judge-only trials, you need more judges and more courtrooms. The government hasn't explained where those resources are coming from. Without significant additional investment, you're just shifting the backlog from jury trials to judge-only trials. You haven't solved anything. You've just changed which institution is overwhelmed while simultaneously removing